Mr. Knowles, you may proceed.
Thank you, Mr. Speaker, and I thank the gentleman from Montgomery County for agreeing to answer some questions. Mr. Speaker, in terms of the component of the bill dealing with tethering, can you give me a brief explanation in terms of the tethering as to the length of the rope or chain, as to the period of time? Can you just give me a brief explanation of that?
So, Mr. Speaker, I mean, they're all laid out right in the bill. It's on page 31. They start at line 22. Do you just want me to read it for you, or?
No, if you want to, that'd be fine. But I'm asking you about the length of the tether and the time in terms of being allowed to be tethered.
Yeah, sure. So here's what we did. With respect to tethering, today, without this bill, there are countless examples of people who are being prosecuted for animal cruelty for improperly tethering their dogs. But yet our law doesn't provide any guidelines whatsoever. None. And I have well over a dozen examples taken from Pennsylvania newspapers over the last year of folks who've been charged with cruelty for causing serious injuries to their dogs for improperly tethering them. So what we did was we laid out just a couple of factors to say, hey, you know what? These are not bright line rules. It's not to say that if you don't do it this way, you're going to be guilty of animal cruelty. But you know what? We're going to give you the benefit of the doubt and say, look, if you touch these bases, then you're not going to be out of bounds. You're still going to be within the permissible type of tethering that won't cause these types of injuries. So in terms of presumptions, and again, all of these are rebuttable presumptions. So none of these are hard and fast rules. You're always going to have the ability to argue your case before a district judge. This does not create a new offense. A lot of misinformation about that. No new offense is being created here regarding tethering. All this does is provide some guidance for folks who might want to tether their dogs and how they can do so properly so they don't get jammed up. So presumption that if you tether an unattended dog out of doors for less than 9 hours within a 24-hour period, when all the following conditions are present, it's a rebuttable presumption that you have that a dog has not been the subject of neglect within the meaning of Section 5532. So these factors to be considered are the tether is of a type commonly used for the size and breed of the dog and is at least 3 times the length of the dog as measured from the tip of its nose to the base of its tail, or 10 feet, whichever is longer. 2, that the tether is secured to a well-fitted collar or harness by means of a swivel anchor, swivel latch, or other mechanism designed to prevent the dog from becoming entangled. And 3, the tethered dog has access to potable water and an area of shade that permits the dog to escape the direct rays of the sun. And 4, the dog has not been tethered for longer than 30 minutes in temperatures above 90 or below 32 degrees Fahrenheit. Now, those are all the rebuttable presumptions that say, hey, this dog's fine. You do these things, you're in, as the attorney who was involved with this indicated, a safe harbor. And you're not going to have a problem there. And you certainly can point to those to the district judge if for some reason somebody were to suggest otherwise. Now you have the flip side of the coin, right? What are some of the factors that are going to, probably give you a problem? The presence of any of the following conditions regarding tethering an unattended dog out of doors shall create a rebuttable presumption that the dog has been the subject of neglect within the meaning of Section 5532. Excessive waste or excrement in the area where the dog is tethered. Open sores or wounds on the dog's body. The use of a tow or log chain or a choke, pinch, prong, or chain collar. And I think most notably, Mr. Speaker, these are not factors that we just came up with. These are factors that commercial kennels already are subject to. So there's a whole body of law that would provide additional guidance and materials on these factors. So these are generally accepted factors that those in the dog world are certainly aware of. But I think what's also important as it relates to tethering is there are certain exemptions, if you will, within the tethering section. So for instance, on page 32, this section shall not be construed to prohibit any of the following: tethering a dog while actively engaged in lawful hunting, exhibition, performance events, or field training, 2, tethering a hunting, sporting, or sledding dog breed where tethering is integral to the training, conditioning, or purpose of the dog. 3, tethering a dog in compliance with the requirements of a camping or recreation area. 4, tethering a dog for a period of time not to exceed 1 hour reasonably necessary for the dog or person to complete a temporary task. So those are all exemptions that apply as it relates to tethering. We've tried to provide some guidance for folks so that they don't unnecessarily and unknowingly get jammed up as they could very well today because there's no guidance in current law.
Thank you, Mr. Speaker. Mr. Speaker, can you just address the degree of the crime in terms of it?
Sorry, Mr. Speaker.
Wanted to make sure you were still with me, Mr. Speaker.
I appreciate it.
Could you talk a little bit about the degree of the crime in terms of summaries, in terms of tethering itself? Summary offense, misdemeanor, felony?
So the look, it's all same as all the other provisions that are listed out in the bill. So generally speaking, neglect is going to be a summary. If bodily injury results as a result of the neglect, it would be an M3, a misdemeanor of the 3rd degree. On the cruelty side, it would generally be a summary, except for instances where you have bodily injury, which would make it a misdemeanor of the 2nd degree. And then obviously when you get up into the torture and the killing aspects, that's where you hit the felony of the 3rd degree, the most egregious instances in this case.
Thank you, Mr. Speaker. Mr. Speaker, in terms of, I'm an animal...
Actually, I'm sorry, because I was thinking of something here. Just to clarify, there is no new offense for tethering. So those are the standard cruelty, neglect, cruelty, aggravated cruelty provisions that would apply right now. Look, I mean, we don't do this bill. People are still getting charged with cruelty to animals. And they're getting charged for improperly tethering their dog. So in my mind, we should provide them with some guidance on how to do it properly.
Thank you, Mr. Speaker. So, Mr. Speaker, I'm an animal control officer, and I'm walking down the street, and I hear a dog barking. And the yard is a fenced-in yard. I can't see in. So my question is that probable cause? And if it's not, can you tell me what would be the reason for me to enter that property if I am an animal control officer?
Sure. I mean, look, every single one of these cases in terms of probable cause, which is a Fourth Amendment assessment, and by the way, we are not in any way touching the Fourth Amendment, we make no changes. So this bill will not in any way change what would allow someone to go on somebody else's property under the Fourth Amendment of the Constitution. So in the end, that's going to turn on a case-by-case basis, and the facts are going to be very specific. I'm not a judge. In my opinion, the hypo you laid out does not rise to the level of probable cause to permit me to go onto somebody's property just because there's a dog barking. Frankly, based on your hypo, I don't even think you could conclude that it's on that property because all you heard was a dog barking and you can't see the dog, so therefore don't know where it is. But it's going to be really difficult to go through every single hypo because all of these are going to be so fact-specific, but I can assure you we make no changes to the way these cases are handled under the Fourth Amendment regarding search and seizure or access to property or anything else like that.
Thank you, Mr. Speaker. Mr. Speaker, I believe yesterday you made a comment relative to the farm community, and I don't want to quote you incorrectly, but I believe that what you said was that this legislation will have no effect on the farm community. And I would wonder if you could give me an example of when would an animal control officer, when would he have the authority to go onto a farm?
Well, again, the exact same places where it is now. We don't change that at all. There are no changes relative to the Fourth Amendment and who's allowed on a property and who's not. We maintain the exact same agricultural exemption in current law. There's no changes to that whatsoever. So anything within a normal agricultural operation is going to be subject to an exemption the same way it is today. under current law, and the Fourth Amendment is going to provide the same protections to property and liberty and everything else like that, search and seizure, as it does today. We make no changes.
Thank you, Mr. Speaker. I appreciate the gentleman taking the time to answer those questions. I greatly appreciate it. I just would want to remind the members.
Mr. Knowles, on the bill?
On the bill, Mr. Speaker.
Ended your interrogation. Thank you, sir. You may proceed.
Thank you, Mr. Speaker. I just want to remind the members, and I'm doing this as a courtesy, I believe, is to let you know that the Farm Bureau is opposed to this legislation. Thank you very much, Mr. Speaker.
Chair, thanks, gentlemen.